number 102, People v. Anthony Lagano.
Good afternoon. Appellant respectfully requests 3 minutes for rebuttal. Thank you.
You have 3 minutes.
May it please the court and counsel, my name is Thomas Litsky, appearing for appellant. This is a straightforward legal sufficiency case. Viewing the facts in light most favorable to the prosecution, the question is whether there is a valid line of reasoning and permissible inferences from which a rational fact finder could have found the elements of harassment in the second degree beyond a reasonable doubt. As the court is aware, to establish second-degree harassment requires that the people are required to prove that the defendant threatened to strike, shove, or otherwise subject another person to physical contact, and defendant did so with intent to harass, annoy, or alarm. An intent may be inferred from the proven facts and consideration of the circumstances surrounding the defendant's conduct, or in this case, his statements. In this case, a defendant, Lagano, known to carry a firearm, told the complainant that he would shoot the complainant's children in the head and kill the complainant. The statements are not disputed. They were recorded by the complainant, and the complainant testified about them at trial.
It's arguably not an imminent threat. Is that of any significance to the legal analysis?
Oh, I would say that it is imminent if there had been threats previously, although not fleshed out in the record what the subject of those other threats were. But in this instance, he threatened to shoot the...
That would make it a credible threat. And I didn't say it wasn't credible. I'm saying, they weren't together when this happened, and there was no time frame put on when those things were going to happen. And I'm just wondering if you think that even factors in to the analysis.
It's certainly, it's one of the factors to be considered. And here the fact that the defendant was known to carry a gun and had threatened to use that gun to shoot the complainant's children is relevant. And also that he knew where she lived. They were in a relationship. This is not some isolated stranger talking.
Didn't he show up when she was talking to another police officer at one point at her home in the middle of the night?
He did.
He drove?
Yes, Your Honor. There's testimony in the record that the defendant drove by the complainant's house. She saw his vehicle, and they spoke at that point on that evening.
So is it your argument that you take all the facts into consideration in determining whether this is in fact legally sufficient? The facts that she knew he carried a gun, he was a police officer, he knew where she lived, and he had shown up, even unannounced.
Yes, absolutely. You have to look at all of the facts. Here, the appellate term found that this was not a genuine threat of physical, the appellate term recognized that genuine threats of physical harm fall within the scope of the statute, but thought that here, this evidence was insufficient. But it's the people's considered position that if the defendant Lagano's statement in these circumstances, coupled with the fact that he carried a gun, does not constitute a genuine threat within the scope of the second-degree harassment statute, that we're not quite sure what does.
So to be clear, is it each of the actions, are they separate threats, or is it all of them together are what makes this an obvious threat of physical conduct?
I'm sorry, I don't.
Is it the threat that I'm going to kill y'all? Is it the threat that I'm going to firebomb you? Is it the threat that your children will have a bullet in their head? Is it all of those together, or is it any one of those individually is enough?
I think in this case, all of it in consideration is sufficient, and that's where the court erred below. Now,
Let me ask
the-
you a different question. What is is it a subjective or objective standard? Is it that she, the victim here, has to perceive it as a threat, or that objectively anyone would, regardless of whether or not she perceived it as a threat? A real threat?
the better approach would be an objective approach, whether an ordinary reasonable person familiar with the context of the communication could believe the defendant's statement that he would kill the complainant and shoot her children. But whatever standard applies, whether it's objective or subjective from the point of view of the complainant who feared for her safety and for her children, the
Well,
people have established.
if she apprehended it as a real threat, and these are very serious types of threats, right? The firebombing, the shooting, the killing, all of this, why not call 911? Why not hang up and call 911?
I can't speak to having been the victim of such threats, but there is evidence in the record that the victim herself was in shock. Also, the victim had this recording, and she was concerned that if she contacted the police at that moment at midnight, she was concerned with preservation of the evidence because she knew it was significant, and it established that what had happened to her. It wasn't just her
And is it perhaps more weight
word.
of the evidence that really is what my question is about versus the sufficiency? That goes more to how the jury might weigh her credibility?
Well, in this
As opposed
case,
to the sufficiency, because that standard favors the people, right?
all of the facts have to be taken into account, and here the trier of fact, Judge Rajwari, heard the evidence, obviously found the complainant to be credible, and found the defendant guilty of the violation. Thank you.
Thank you.
Good afternoon. May it please the court, counsel. My name is Peter Brill, and I represent Mr. Lagano. I'd just like to initially push back a bit on the assumption that the initial statement is or was, in fact, a threat.
Let me ask you, subjective or objective test?
I think it has to be an objective test, because each and every person's mental state can't be part of a consistent analysis of the statute.
So if she testified, I wasn't afraid of him at all, I know him, he does this all the time, it's not a big deal, you would still say if it meets an objective standard, he can be prosecuted?
I would say that there's a certain discretion with regard to the prosecution when that comes about, and that type of statement might negate the proof, but I think from an objective standard, you'd still have to be able to prosecute a case like that, because there may be other factors that go into why a person would say that. But here, Ms. DeRazio was very clearly knew what she was doing right at the beginning. She knew she was taping this conversation. She had a specific intent as to why she was taping this conversation. She wanted to get Mr. Lagano in trouble with his job.
But again, doesn't that go to the credibility? That's not about the sufficiency, unless you think she's completely incredible, which I think that's a very hard argument to make here.
I don't think it's a question of whether she was completely incredible. I think that the sufficiency versus it's a fine point. But in a situation where we have a 54-minute conversation, and 46 minutes of that conversation is Ms. DeRazio winding him up and pushing his buttons, knowing exactly what she wants him to say so she can get him on tape, so she can take that to his job, along with the argument that, well, he's in uniform on Facebook, so I'm going to get you in trouble for that also. I mean, it seemed like...
Mr. Brill, don't those facts actually give him more of a motive to harm her?
Given the testimony and the record of the nature of this relationship, this was a volatile verbal relationship. There was no actual violence in this relationship. So there's no basis to believe that he had any interest in harm.
You don't need actual violence to prosecute a harassment.
No, of
claim.
course not. No, I agree with that. But the point being that the people's argument rests on the concept of he has access to a gun, so therefore it's more likely.
Well, does that count at all, or we should just disregard it entirely?
I think it doesn't really count. You know, we have 1.5 million families, households in this country in this state, that have access to firearms. You know, if someone said, I'm going to stab you with a fork, we have probably 100% of households in this state that have access to a fork.
But it does go to, but he's a trained officer, trained in the use of the gun, perhaps very
would-
well versed in how to firebomb, but put that aside for one moment on the firebombing. It does go to whether or not, if we're using the objective standard, any reasonable person under the circumstances would take this as a real threat that someone who has a gun, is trained in the use of the gun, is actually threatening the use of the gun. On the
Respectfully-
children at a minimum, on the children at a minimum.
Judge Rivera, respectfully, I think it actually argues in the opposite. We have a responsible gun owner who's trained in the use of that gun, would know to use that gun responsibly.
Well, he's also an officer who one would think is measured in any statement, even in a phone call where, agreed, emotions are running high. To say something, I mean, if I understand the record, the next day, he went to his commanding officer and said,
I said some things I shouldn't
I
have.
did something wrong.
Right. No, absolutely. But I think he
And
knew.
in fact, contradicted what he told her on the phone. On the phone, he said, I never threatened your kids, and then he says to the commanding officer, I threatened to shoot the kids.
I don't think that's exactly what he said to his commanding officer, but I think it's important also to go back to my first
But he
point.
was concerned that he shouldn't have said what he said to her.
Because I think he was trying to head her off at the pass because he knew that she was going to bring this recording and get him in trouble. So he figured that he could minimize that by bringing it up himself. But the threat that he allegedly made is not really a threat. It's a contingent threat, right? Your kids are going to get a bullet in the head, not I am going to shoot your kids. And I think that there's a significant distinction there as well, and I know you might not agree with me.
That is quite surprising. A parent, someone has a gun, they carry guns, and they say, I'm going to harm your child. I don't know if one would argue it's a contingency. The question would be whether one would believe that they're making a threat they intend to carry out
I
or are
agree.
capable of carrying out.
Well, that part I agree with. I think in a situation where he is making an observation, is the way I would say it, that your kids are going to get a bullet to the head, doesn't
So
actually...
you're saying because he didn't say, I'm going to put a bullet in your kid's head,
I think
that
that
takes
if
it
it
out of
doesn't-
threat?
If it doesn't have a specific intent in the statement, that doesn't necessarily mean that he was intending to do it.
So it might just have been your kid might be the accidental victim of a drive-by shooting.
I don't think necessarily that, but based upon the entire record, given the relationship and given his innate knowledge of her children, an observation that this is the road your children are headed down could be just as reasonable a takeaway from that statement.
Again, sounds a lot like a jury question.
And doesn't he say right after that, I'll kill you all?
Well, it was about 6 minutes later, because again, he's getting wound up, his buttons are getting pushed, and all of a sudden,
Interpret shooting in the head in light of his later statement, and I'll kill you all, to mean that he would kill the children as well?
I think I'll firebomb you, I'll kill yous all is the statement.
Firebomb your house.
And doesn't the 6 minutes also cut against your arguments? Because it's not just him being wound up and then saying something like an outburst at 1 second that he regrets. He waits a full minute and a half. I mean, we have the tape, we can listen to it, and so he's thinking about it, and then he again he continues with that threat. So doesn't the timing of it,
I think it cuts
Isn't it
both ways, because
significant?
again, a few minutes later, when she directly confronts him, he completely denies it. So if you're
But
analyzing
again, the
his,
difference between legal sufficiency and a jury determining beyond a reasonable doubt, aren't they different?
of course, they're different, but the analysis here is whether, as Mr. Litsky said, a reasonable jury could actually arrive at this. Was there clear and present danger, as prior case law in our state has, that this was actually something that was going to be carried
Did
out?
you make a weight of the evidence argument in appellate term?
Forgive me, I can't recall at the moment, I'm sorry. So ultimately, we believe that this was actually a scheme or a plan that was really carried out by the complainant to get a specific result, a result that which she did
Well,
get.
let's say you're right about that. Let's say it's obvious on its face. Let's not even say it's a question for the fact finder in this moment, or any fact finder would have found it out that way. Does that mean he didn't threaten her?
No, it's
So
not a question.
she incites it, but he actually makes this threat, he's somehow not criminally liable for it?
It's not really a question, and I take your point, but it's not really a question of whether.
It
he
sounds like
made a
you're
threat.
basically saying she doesn't feel threatened, as opposed to the objective standard, which is what I asked you up front.
She, A, doesn't feel threatened, but the things that he said, our position is, are not threats that are sufficient under our current law.
So it's her fault.
No, not at all. But it's an argument that she was a willing participant in, and she had her own motives for recording that. And I think she fully intended to get that type of outburst on tape so she could use it against him. She was jealous of his other girlfriend. She was angry at the way she was being
Again,
treated.
all that may be true. The point is, did this gentleman violate the law with his statements? That's the point.
Agreed. And going
She
back
may have
to,
done all those things. I'm not going to argue that with you.
right, but going back to Dietz and other cases, is this a clear and present danger under the circumstances? No. He's on the phone. He's
Is
not.
that the standard, clear and present danger?
That's one of the standards that's been,
On the section that had to do with sufficiency, it seemed the court was focused on something else.
not on the
Right?
standard.
It didn't use that standard, did it?
Not on the sufficiency standard, correct.
Correct. And isn't that what we're worried about in this case? A different provision, but we're also worried about the sufficiency.
Right,
That's what we're trying to resolve.
understood.
Yeah,
Thank you.
thank you.
Very briefly, this case did not involve a threat with a fork. This was someone that was armed, had a gun, obviously knew how to use it, and then threatened to kill the complainant. And it's not about blaming someone who's in a contentious relationship or the end of a relationship.
Does it matter
His-
whether or not he actually intended to shoot her? Is that what the statute requires?
No.
Or does it require that he intended to alarm her,
That's correct.
Right.
That's correct.
annoy
Threat-
her with this? As my fellow member of the bench has suggested, someone who's a parent would be troubled by someone suggesting that their children are going to get bullied in the head.
Yes, and this is not a, and the remarks are obviously serious in nature.
Yes.
And she got the message, she was afraid.
They do
and-
appear to escalate during the conversation.
I'm sorry?
They do appear to escalate during the conversation, I think.
Yes, but,
Several members have pointed that out, I think.
yes, thankfully, it didn't escalate further than simply words that were exchanged. And of course, the statute specifically does not require that.
I'm a little unclear. When was he arrested? Was it the following day?
It was that morning. He came to work and I'm not sure if he was to work that day, but he reported to a supervisor at the precinct that he said something he should not have said in a heated conversation. He said that he would shoot this person's children in sum and substance. That's what testimony was from the captain. And he was arrested later that day following
It
the
was an
investigation.
investigator who spoke with the victim, yes?
Yes, there was a supervisor at the precinct who spoke to him. His
But I mean,
state,
spoke to her. Didn't someone speak to her?
yes, there was an investigation, and the complainant did speak to the police, and he was charged. And this case is not Dietz. Dietz did not involve a firearm. Dietz did not involve a threat to kill. And the cases that Dietz relied on, Watts and Todoro, those were expressly conditional or equivocal statements that were made. Here, there's no way this was equivocal in nature. It was very clear, and thankfully, it ended with the officer simply being charged and not something worse.
Thank you, counsel.
Thank you very much. We ask that you reverse the appellate terms order.
Thank you.